outstanding show for everybody today. Sonny, how are you, sir?
I'm doing well, Joe, though I just heard on the radio that we eclipsed the 4 million mark in terms of those affected by COVID-19.
You're talking about
in the United States.
in the United States.
Yeah, so it's sad.
It is. It's incredible, really.
And I think new cases are, 170,000 a day.
You gotta just wonder a little bit and wonder. I mean, we're all social distancing for the most part, right?
Yeah.
And what is the? I get it. It's
And
flu season.
our mayors and governors are doing their best to try and contain it, but this thing is just out of control.
Absolutely. Let's bring in our guest to weigh in on that topic and introduce him, if you will, Sonny.
Absolutely. Attorney Jared Jacobson is here today. Jared is the founder of the law firm of JJ Law. The firm focuses on employment-related matters, including workplace violence and safety audits, social media audits, employment discrimination, sexual harassment and sexual assault at work, age discrimination, retaliation, wage and hour claims, whistleblower claims, as well as some real estate and sports and entertainment matters. Jared has successfully resolved employment issues for nearly 20 years. JJ Law has a reputation of being a client-focused law firm, meaning they keep the clients informed every step of the way in their claim. In fact, they challenge their clients to be involved or be all in when resolving their claims. This way their clients get the result they want instead of what someone else thinks is in their best interest. When you hire the firm of JJ Law, you'll get exceptional legal representation performed in the most professional manner. If you have an employment-related issue, Jared Jacobson is the attorney you need to resolve it. Jared, if you would, please tell our listeners about yourself and about JJ Law.
Thanks, Sonny. Thanks, Joe. It's great to be here. I really appreciate it. It's an honor. So, Jared Jacobson Law, what we do is primarily we represent individuals in employment claims. That could be severance matters, employment agreements. Clients often come to us when they are leaving their workplace, whether it's their choice or not their choice. And sometimes they have an opportunity to move their matter forward if they, as Sonny put it very well, if they're all in. And so really what we try to do is to transition them out of the employment workplace and onto something else in their lives that is helpful and productive for them, and which is really difficult, as Sonny mentioned, this day and age with COVID. The workplace is really changing, and it's affecting a lot of employees significantly. And when somebody loses their job, it really impacts their lives, their families' lives. And so it's important that they're able to transition into a productive process to get them to the next step.
And tell our listeners how you formed JJ Law.
I'm sorry?
Tell our listeners how you formed your law firm.
Well, we formed the law firm in 2009 in September, and so it's been around for a little while. And we represent executives in their compensation matters also, and often they come to us through referrals. We don't do a ton of marketing, but I'd like to say that clients are happy with their experience, and they refer other people to us, and we appreciate that.
And it's a. By the way, I love your website. It's very cool. It's a very unique website.
I know, we were talking about it before we went on air.
Yeah, I went through it last night, and I was like, this is one of the coolest websites.
I appreciate that. Thank you. I'll take that as a compliment.
Yeah.
You should.
Having said that, when you're obviously talking about employment law, very emotional area, lots of areas. I was looking at the scope of your practice, very impressive. And we're going to talk about the employment area first, but it's an area of law where anybody who's in those situations, whether they're being harassed or discriminated against, or one of those situations, it can be an overwhelming and a daunting task, and something that where they feel lonely and nervous and scared.
And I would think most of your clients are probably in a vulnerable situation. The people that are harassing them are, I would imagine, for the most part, superiors or folks that are above the individual that is in a position to carry out that kind of activity, right or wrong.
Absolutely. And there's obviously a power dynamic that Sonny's bringing up, and it takes months, sometimes years, before an individual will come forward and say something. And thankfully, just to kind of lay it out, there's discrimination if somebody's being treated differently based on a protected trait, their race, their gender, national origin, their age. But then there's retaliation. And we all have a common definition of retaliation. Somebody does something back, they retaliated. But there's illegal retaliation. And if an individual complains about a protected trait, even let's assume whether it's true or not, if they complain and then there's what's called an adverse employment action taken against them, they're fired, they're no longer a good fit, is normally how it happens.
Sure.
Well, that is a claim in and of itself, and they're usually clearer claims. And in this modern day with technology, you'd think it'd be easier to prove it with text messages and emails. You'd think.
Interesting. It's obviously people are listening, and somebody going through something like that. It's such a wide scope. We've talked about this. It's amazing, Jared, because this is the one area of the law. There's so many. We've done so many shows.
We have.
But it's.
And usually the documentation issue is
Sure.
the issue that always rears its ugly head. How do you document, sexual harassment?
Well, the interesting thing is the law will reward you. The law will protect you if you go and complain. It's got to be a protected, so I said before, protected traits, race, gender, national origin. But then we have protected activity. So if you make a complaint about something which the law will protect you, you have potential recourse that you could take. And if you complain, I don't like my boss or the working conditions, although there is some anti-union labor activity there. But if you make a complaint and it's about one of those things, the law says this is serious.
Yeah, but how do you actually make a verifiable
Right.
complaint, say in a small shop, where the person who's actually doing the harassing is the person that you ultimately have to make the complaint to?
That's extremely challenging. That's a great question.
Well,
if they're the only person.
Right.
Anybody above you with hiring and firing authority, you can establish that protected activity. I'm sorry.
No, but it's really interesting because, having said that, I'm thinking about somebody out there, and I'm sure you've heard it a million times. I was afraid to do it. Because this is an at-will state, right?
Absolutely, at the will of the employee or the employer.
Right. And so, having said, what is at will? What does an at will state mean?
Right. Define that for the listeners.
So, an at-will employment generally means an employee can leave their place of employment if they choose to. They can quit, and an employer can terminate an employee for any reason or no reason, unless it's based on a protected trait, or they engage in protected activity, or, for example, their whistleblower complaints, which we could get into if you wanted to, but
Sure.
They're similar in nature. When we're talking about retaliation, when you make the complaint, and we went into that, but that's generally the basis for at-will employment, and the only exception.
What is a protected trait? Give us an example.
So a protected trait is, if you have a disability, you need an accommodation. You go to your employer. They're required to engage in the interactive process, which means they'd have to try to find, unless it's an undue hardship, generally financially on their business, they're required to try to help you to do a job. Now, you have to be able to do the job with that accommodation. You can't say, I'm out of work, I'm sick, and I'm never coming back, and just hold my job.
Sure.
But that's an example. Age. So, and these things come up subtly. Technology, it's not really your thing, and then they're replaced by younger workers, which I think is a problem, facing, a ton of employees out there.
And what about the gender and religion? I assume that those are also protected traits.
Gender, religion,
Obviously, race.
and it's just, and that's what I was thinking about that, especially due to the, upheaval, and rightfully so. And this is the tip of the iceberg.
Sure.
It's the second pandemic, and that's what we've been seeing recently. But it's, these things are, it goes much deeper, and it's systemic, it's institutional.
So let's start from the beginning, because this is interesting. should people be documenting if they feel like that, things are and the reason I say that is because you mentioned that if you kind of give notice or complain and say,
right.
What should be first, because I'm putting myself in somebody's position, and say somebody's been harassing me, and because my religion or my, obviously a situation, and I'm nervous because it's maybe a small sized workplace. Are you saying that I'd be better off if I made a complaint first, or should I document things until I get to see? To me, I'd be calling you immediately.
Sure.
I'd want to be guided through this process.
Because you raise an interesting
Absolutely.
issue. I mean, in my practice, the Pennsylvania Workers' Compensation notice is an important issue. I mean, the injured worker has to give their employer notice of their work injury within 120 days of the occurrence of the injury. So I'm wondering, in a situation where you're being harassed at work, do you necessarily have to give the employer notice, or is it important to document the harassment first and then give the employer notice?
These are absolutely on point, these questions. It's what everybody wants to know, and
By the
rightfully
way,
so.
you'll get used to that when it comes to
That's great. I appreciate it. I love it.
I typically school Sonny in those areas, so I'll go with the
He
credit.
does. He's my mentor.
I'm his mentor. He's in trouble. But no,
It's extremely important to document everything. Obviously, if there is written documentation through a text message, email, you're going to save that stuff. You're going to make sure it's somewhere where you can keep it. Now, there could be issues sending work emails to personal emails, and it's another thing. But as I mentioned, with retaliation, the law protects you, meaning you potentially have a claim against your employer if you engage in that protected activity. Now, engaging in protected activity means you're required to make that complaint.
Yeah.
And it has to be to somebody that has the ability to fire you, and that's why you get that protection. Now,
So you can't make the complaint to a coworker.
you can, and that does not trigger the protection.
I see.
HR is possible. It has to be somebody, because you're putting as you correctly meant, you're putting yourself out there. You know what I mean?
And so how soon should you do it? Because you want
So
document.
I will
Yeah,
let.
good
So
question.
this is the answer. So the answer is, when someone calls me, I say to them, "Are you on your way out or not?" And that means voluntarily or involuntarily. It's you let me know. Are you? Because I don't know. I know the law. You tell me the facts. We figure out if you have a claim. But are you on your way out or not? You don't have to be sure, but you have to make a decision, because ultimately, if you're on your way out and it's up to the company, decent sized company or even small companies of outside lawyers. I have a handful of business clients I work for. I do counseling. I don't do litigation. I don't do defense for them for whatever reason. But you'll get put on the 3-month plan. They call them performance improvement plans, PIPs.
Right.
Yeah.
You'll get put on a plan, and you could be on the plan. So if you think you are on that plan but you don't know it yet, if you have a complaint, that's when you engage in protected activity, because guess what? You were going to get fired anyway, and now you potentially got fired because of your complaint.
But Jared, is there a requirement where the victim needs to give the employer time to cure or correct the problem?
It'll probably be after the employee's asked to leave,
Okay.
after they get fired. But so what happens? It's a great question. So what happens is, if the employer doesn't actually know about it, either knew about it, didn't know about it, or shouldn't have known about it, or let's assume whether they should or shouldn't have known about it, if they actually didn't know about it, because if you're reporting it to a supervisor or someone, like I said, that has hiring and firing authority, that knowledge is imputed to the organization. So now we assume they're liable, and that's generally who you're suing. But what they have is an affirmative, and maybe this is why you're asking, they have an affirmative defense. So if you allege they broke the law, their defense, the company, can say, we didn't know. How would we have known?
Yeah.
Do they have a handbook? Do they have policies? Do they want to know? Are they willfully blind? You know what I mean?
Well, let's talk. It's all really good stuff, and so realistic in a daily.
Oh, it is.
So
Especially now.
let's talk about. And I'm Jared. When you're talking, I'm thinking about scenarios that are common sense ones. Like, let's give this one an example. Let's give this the type of notice you should give. I'm going to take a shot at this, but you probably, for your purposes as an attorney, an email would probably be a good idea, except it's probably less personal, for a person to do it. So I'd want to walk into my boss's office and say, listen, Mr. So-and-so, this is what's going on, and, everything's cool, but I'd like you to help me out there. Now, immediately, probably no different than like an injury, Sonny. Everything's good until it actually happens, right? It's a red flag either way, right? Somebody tells you about an injury, now all of a sudden people are, their company's treating you, you're on a cold side of the building now, and
Sure.
Jared,
Very similar.
In your situation, you give the notice. Personally, it's you can manage the tone of your voice that way. You can say, listen, I'm a total company person. I love you, but I'm being harassed by this particular person. Can you do me a favor and work it out?
You're out.
Nobody
likes a complainer. Can't forget that.
That's true. I got you. No, but it's a good point. Or Jared, do I send an email? That is documented right there. It's sent, and at that point, you're covered.
Sending an email is not always a sure thing, because you have to remember that if you're doing it at work, the equipment, the system is owned by the employer. So if you don't make a copy of that,
and they're managing. Oh yeah.
How about if you do it from your home computer?
You got to give them notice. Writing is the best.
Yeah.
The challenge is getting over the fear of giving the notice. Usually,
right.
It's just like, because if you decide you're on your way out, well, then you can put certain protections in place to, you can protect yourself. You can do certain things, especially if there's a lawyer, for example, ghostwriting your correspondence. So if I have an opportunity to speak with a client prior, like they're in their job and they're like, I know they haven't been fired yet. They know they're on their way out. This is going bad. They can start, and I'm not suggesting setting the company up if there aren't actual violations, but if you believe there are and you haven't said anything, now's the time. And then there's a potentially more protection, and again, then there's more leverage. Doesn't mean you're going to, wind up filing a lawsuit necessarily, but you can stack those pieces together and build a defense, and then negotiate a severance package, for example.
So that's where, in my opinion, I would want to, just like in a work injury type situation, I'd say this right now. I'd want to call a Jared Jacobson and get the counsel like almost immediately, because you have a lot on the line. I think you need to navigate this properly to do it the right way. And I'm going to take a shot at this also.
Even more so in the employment law setting.
Yeah.
I really think
similar to workers' compensation.
I think the odds are stacked against the worker in an employment law setting or issue.
And the workers' lawyers.
Yeah.
True.
True. Yeah, but you need to get that counsel early in the game.
Right.
As early in the game as possible. I mean, what good are you? I'm sure your documentation is the way to go.
Absolutely.
And there's a million things you could, I was hoping it would stop, and it didn't. But documenting something for 6 months or a year, you would imagine that some judge would say, listen, if it was so bad, how come you waited so long? You know what I mean? And yet at the same time,
absolutely,
you got all the documents. Now, if you go on the second day, you don't have much of. I mean, your case is less, but at least you're going to be. So my point is, as soon as you see something happening, and tell me if I'm wrong, Jared. Immediately, I know this is self-serving. You would think, but the truth is, from where I'm sitting, it's not. I'd be calling an attorney immediately and saying, listen. This is, if you feel like there's really a problem, get that education early in the game so that you can navigate it properly. You may get some advice that may help you avoid things, but the truth is, you're going to also it stinks to have to go through it. To me, it must be way worse when you go through it and you get kicked when you're down. In other words, your rights are violated.
Yeah, and I would think most people in these situations want to keep their job. They don't
they
necessarily
do.
want to lose it.
They may not be running. They may not be running to make that complaint. Even if I am in touch with them first, because guess what's going to happen? They're probably going to lose their job.
Yeah.
And so they better be. I don't know. No cursing allowed, right? They better be pretty.
That's the only rule.
Right, no cursing.
That's the only one.
You got to be pretty sure that you're on your way out, because once you make that complaint, there's a reason that the law will protect you, because something's probably going to happen.
Yeah.
And so
So
most people don't. Well,
The overwhelming majority of your clients are likely, in other words, once they make that in other words, that's typically the situation.
if you're lucky enough to, to get into that situation, because there's probably already a problem of some sort, whether it's illegal or not, it's to be determined. But there's probably already an issue, and that's why they're calling.
Sure.
When we're talking about harassment,
That's
and
an
in small environments, difficult, like you said.
Interesting outcome, because being an employer, if somebody brought an issue like this to my attention, I'd want to know about it as soon as possible so that I would have the opportunity to correct it.
Well, that's an ideal employer. I mean, that's what you're supposed to do, and that's why you would have the affirmative defense, which basically says, as soon as we learned about this, we took all remedial measures to fix it. But the crazy thing is, you get somebody that complains, and then these things keep happening.
Right.
And then you hear from a lawyer down the road, a defense lawyer, that says, my client did every single thing they could to change the situation. And you're like, no, they actually didn't do anything. They except continued to retaliate against my client.
Yeah.
So, but it's, I joke, but it's,
So if you advise somebody, what type of notice would you tell them to give? I know written's good, but give me an example.
An email. If you're brave enough to walk into someone's office, I mean, if it's the person that's doing the harassing, it's probably not going to work out so well. But an email, a text, it depends on the nature of the harassment. If someone's been harassing you by text, maybe that's the perfect place for it. Stop, please stop, please stop. But don't write afterwards, LOL, exclamation mark, because you're nervous. Because that now a judge looks at that and says, maybe you kind of liked it a little bit.
Right.
It's like you were asking for it because you're wearing a certain outfit, which does not mean that you want your rights violated.
Exactly.
Did I answer your question? I know you.
No, it does.
It's an important question.
The great thing about sitting in my chair is I get to be the listener. So in other words, I get, I'm talking to two attorneys and, can't explain, obviously, what the law and all those things, but I know people in general are out there thinking, who are in this situation, are going, just tell me what I should do here.
Yeah,
So
this is a complex area of law, and it's got a lot of nuances and idiosyncrasies. So I'm glad we have Jared here.
Absolutely. Let's talk about what can be considered, for example, sexual harassment, because it's I'm not saying it's there's a wide array. There's a lot of scope there.
A lot of gray areas.
Right, exactly. Like I've heard stories.
Putting your hand on somebody's shoulder.
Sure.
That could be, deemed sexual harassment under the right circumstances.
And so if you would, Jared, talk about, the different definitions of what people would consider sexual harassment.
Well, I think it's a good place to start. It's pretty contextual. So there's a subjective component to it, which is the person being harassed. But maybe to start from the beginning, unwelcomed, unwanted sexual advances.
Sure.
That are, the definition goes, not to be, too technical, severe, and depending on where you are, depending on your jurisdiction, severe and or pervasive. So they're really serious and they go on for a long time. If it's a one-off situation, the defense will argue that, how bad really was it? So, and so we could be talking about, it can be contextual. So, as Sonny mentioned, somebody putting their hand just on someone's shoulder. Well, do we have a hypersensitive, not to judge, do we have a hypersensitive plaintiff that maybe had some sexual abuse when they were younger?
Sure.
Does that count? I mean, these things are taken into consideration. Who's the person putting their hand on their shoulder? Is it a superior, or in the standard photograph, someone standing over their shoulder and asserting their power? Because that's really what we're talking about here. It's a power play, sure. And it's a dynamic where one individual is has to be subservient in their feelings, in their conduct, their behavior to another, simply because of that imbalance in power. But it's not allowed. It's illegal, and
I've heard different language. I mean, so tell me different language somebody might use.
Like a hostile work environment.
Yeah,
as an example.
That we'll just say somebody is constantly saying curse words, and sometimes sexual curse words,
Sure.
some really
Yeah, sure.
really disrespectful curse words, or I've heard stories about, for example, somebody having pictures that are inappropriate,
Pornographic pictures,
Right.
showing them to everybody, laughing.
right, and the person can see your screen, and something like that. Can that be considered a type of sexual harassment?
If it makes somebody within the work environment uncomfortable, there are people that would disagree. How far are we going to go with these things? I find myself on both sides.
Yeah.
Honestly, I really do.
Does a complaint, does that start with a complaint though? For example, how would somebody know? And the answer should be, because I complained and said it was uncomfortable.
Yeah, when you gave that example, I immediately thought of an employer playing Howard Stern, at work.
That's a tough. These are tough questions. That's a
Yeah,
tough
and
question.
somebody
Yeah.
complaining about it just because of the language that's used on their program.
Sure. I mean,
It could be against somebody's religion to complicate it, to hear that stuff or to see
Oh.
that stuff. Now we have two people complaining, and
Right.
we have two individuals arguing about protected activity. That employer needs to look out.
Yeah, no, you're absolutely right.
That's a tough situation.
so
Sorry.
we're talking to Jared Jacobson on the Pain and Wellness Hour with Sonny Banks. We're talking employment law here on WWDB 860 AM, and here's a very timely question. And I always find myself when I'm talking employment law. You talk injury law, talk different types of things. I haven't laid. I worry sometimes that I'm being random in my questions. Like, in other words, am I making it? But
You're asking great questions today.
I appreciate that, and
It's because I wrote it for him.
you should get used to that, Jared. We're going to do a lot more shows together. Having said that, here's one, Sonny.
Oh,
Very politically crazy time in this country. Okay.
absolutely.
We've done a number of different shows. Families are being hit hard. You got the left, the right, Democrat, Republican, and different ideologies in their own families. And
I'm a left. I live with a right.
Right.
I'm married to a right, I should say.
I can't.
And then you have offspring. So who knows what? They're a little bit about everything, right? And so mine are.
The next one is the divorce attorneys that we're going to bring on the shows. I'm joking.
Oh boy.
But here's the thing. What about that scenario where, because there are literally, it's so out there that, and with social media, that you could see that people on either side wouldn't want, can you be discriminated against
I knew you were
or
going to
harassed
ask this.
based on your political?
You gave him this question.
No, I actually thought of it.
No, this is a good question.
Very good.
Thank you.
I think I know the
wearing
answer.
a MAGA hat or a Trump shirt
Right.
into the office, is that going to get you?
Right, exactly.
Get you-
I'm going to say none of this is legal
Fire
advice,
harass.
first of all.
Right. It's not, but I mean,
Do not believe anything. Right.
can
It's a good question.
I'm wondering if somebody, especially a superior,
Mhm.
whether they're left or right, and they know somebody's got specific beliefs, and I know I've talked to a friend of mine who, I won't say his name, but I want to hear Jared's take on it first before I give it a
And then he's going to tell me what the answer is. So, no. So here's what I'm thinking. So in a private organization, if you come in and you say, "Listen, I don't like this candidate. I like this candidate. This is the way I lean. These are my views." That's not, as far as I understand, protected. I could be wrong. I honestly am not sure. But in a government organization, you can say you're not supposed to be discriminated against if you are espousing political views. There should be greater rights, and there are also other types of rights, like due process rights when someone gets let go from a governmental organization.
Sure.
So I think you have protection to some degree.
And some of the, if it's a
Is that
government,
right, Sonny? Do you know the answer to this?
I don't know the answer to that, but I would think
think.
that you would have more.
well, I have some. I'll jump in on it. If
No,
you
go
have a
ahead.
collective bargaining agreement, you're in the union.
Absolutely.
There you go.
Okay, so that if especially we've done
And that's a contract by employment to some
Right,
degree.
right,
Right.
and then then your rights are spelled out.
exactly, but a friend of mine.
But they require contributions sometimes, right?
Well,
True.
I'm sorry, what were you
no,
saying?
You
you
would
saw a
know.
wrench in that one.
I know.
By the way, well, here's a good example. The firemen's union in the city of Philadelphia, Local
Yeah.
22, they backed Trump, and a lot of their members were absolutely incensed A lot of them supported Trump,
Right.
but a lot of them didn't. Okay, and they have an African American,
Reasonable ones.
The African American community groups that they have in there, they're not represented on any of the boards. So the leadership backed Trump, and there was a lot of backlash.
There's a history in that department
but
about
there-
those issues.
Well, and typically, like with the police is a Republican, or typically Republican supporting.
True.
But having said that, I'm not getting political with that. I'm not saying, but you
I
mentioned
have no
something.
objections.
But you mentioned something interesting though, Jared, and that is making contributions, right?
Mm-hmm.
They're making now typically with political contributions, they bring them up at the membership meetings and stuff like that, and it's all in favor say aye, whatever. But wondering if so a friend of mine works for a big bank, and this is why I mention that,
Mm-hmm.
and he's a Trump supporter, but he keeps it low because well, they said if they found out that he could lose his job. It's a big bank, and because they're all supporting Black Lives Matter and other different, Democratic, stereotypically Democratic
Liberal groups.
liberal groups, and obviously they're not conservative groups. So the point is, so what you're saying is it's I mean that's got to be a new thing, because I can tell you that the venom between people is crazy.
Yeah.
Let's take it another scenario.
It doesn't mean it's not going to happen. It just means, is there legal protection or not, and can you establish that protection?
And maybe there are
Needs to be-
methods of treating somebody poorly because of something, because of a difference. Maybe, now take this shot, Jared. I just created a whole new area of law right here.
There you go.
I just did it. Awesome.
It's like, give me a cut if you
I
give
want
me
a cut.
cut.
Bingo.
It's a great question. It's like,
But and probably, could you imagine right now around the country how many employees and what's crazy about it is this, potentially, because maybe this employee has worked for this company, probably a good person, maybe a great employee, but maybe for a couple of years when these issues were not that big of a deal.
Sure.
Or maybe 5 years ago, and so now
not for long.
Yeah, right, exactly.
Right. And there's so many clandestine ways to discriminate
And
in the workplace. It's incredible.
And that it's amazing. And now, I mean, anytime you go to file a claim against an employer, they let somebody go. If they can say, in pre-COVID, if they could say it was due to financial reasons and show you their books, what are you going to say?
Right.
But, so this is something that's been on my mind nowadays. What employer can't say that? Especially when they just took money from the government, said they were going to retain all their employees, committed fraud, and that's a segue into whistleblower work we can return. But the point is, these companies can stand behind any reason that they choose as a defense, and pointing to, we're just not doing really well. Well, you have to prove, if you're alleging discrimination or retaliation, it has to be because of that you're alleging.
Yeah.
It can't be like, in the alternative, well, it could be this, it could be that. Well, then it's not
So
that.
it's hard to prove.
Yeah. So
Yeah,
listen,
it's
we
different.
talked a lot about how tough these claims are.
But before we go
Okay.
to the next one, let's pay some bills.
Sure.
And we'll be back with more of the Pain and Wellness Hour with Sonny Banks and Sonny's guest Jared Jacobson after the break. All right, ladies and gentlemen, welcome back to the Pain and Wellness Hour with Sonny Banks, sponsored by Tony Shore and Pinnacle Medical Plus. Sonny's guest is Jared Jacobson, founder of JJ Law. And we're talking employment law. I know, Sonny, you want to go in a specific direction. We're going to go there. But you also do sports and entertainment, which my father told me my whole life never to give up on your dream. So I've been eligible for the Major League Draft. Maybe I got the wrong agent. I don't know. But we'll talk after the show. Hold on. Where did Jared go? He seemed to bolt out of here. Go ahead,
All of a sudden
Sonny.
he went silent. So before we took the break, I was going to ask Jared, we talked about how difficult it is to win these cases. So I guess my question is, how successful are you in these cases, and what exactly are you trying to get for your client? Are you trying to get them reinstated in their job? Or are you trying to get them a lump sum settlement or something else?
It's a great question, Sonny. And so what I'm trying to figure out when they come in is, what do they want? Like, what are they looking for? And what do the facts, that surround their termination, let's assume they got fired for whatever reason, what's there, what are the facts surrounding their termination, what do we have to work with? And that's why it's important. I ask for a pretty large intake. It's an initial step to see the commitment of the client,
Right.
to fill it out and let me know all the facts they can think of.
Sure.
And they'll have to provide that for themselves if they're going to pursue it to another attorney. And then I'll take a look at it, and I'm aware of what the laws are, and I can kind of match up the facts in the law and say, like a law school class, and say, is this something? And then, not to sell the process short, then we can kind of work in, well, here's the practical approach. This is what's actually going to happen in my experience. Just because the law says you're going to get your back pay, your front pay, attorney's fees paid for, will they pay for that? Economics that come out of your pocket. You lost your job. Now you're missing payments on your mortgage. So to quantify all that is not generally how it's done until 3 years down the road. So what we try to do is figure out what is it that, how can I help? And ultimately, if it's approaching the company, seeing if those facts that were presented allow us to create leverage. So you can go to I say you can go to your employer and put out your hand and say, can I have some money? You just fired me. If you want severance, let's call it separation pay. Mm-hmm. Or you can say, I think you did something really unfair, and maybe whisper it was illegal, and then put out your hand. And chances are it's not a good business decision. They're not going to give you the money.
Okay.
Or you can find leverage.
So assuming you have a claim that you're going to accept, how successful are these claims? These employment discrimination,
if you have evidence,
sexual harassment claims.
Well, so sexual harassment claims can generally be more successful. Usually there happens to be the nature of it. There's more evidence of it. There's cameras in the workplace now. There's social media.
Right.
So what's successful?
Plus, I would imagine that an employer doesn't want that stigma of being found guilty of a sexual harassment claim.
And if they've had, and it matters whether they've had notice of this type of thing before. Mm-hmm. So irrespective of what happened with this individual now, like if the company had one of these a few months ago and now it's happening again, and they said they did everything to get rid of it, well, the value of that claim just went up. And so, unfortunately, people are pegged into the value of their settlement or negotiation is going to be based on how much they earned. Right. Unfortunately, there are compensatory damages, garden variety emotional distress without having to go see a mental health professional. But it's, you can look at past cases. Settlements are not as, they're confidential a lot of times. So you got to kind of ballpark it and then discount it for an earlier payment. So we're trying to get the money, and whether you want to call it front pay or back pay, it's just an amount of money. It's taxed as wages. I'm not a tax lawyer, but it's generally W-2 income, and then you can split that with compensatory damages, like somebody's just, this is killing them. It's really affected their life, and it's taxed more favorably. We can work those things out, but we're generally trying to get them some money.
So you're usually after a lump sum settlement, not reinstatement of employment.
Absolutely.
Which makes sense. You don't necessarily want to put that person back in that same
Nobody
environment.
really wants that.
No,
it's and it's when somebody's going through something like that, it's always an emotionally difficult time for
it. Really is. Unless they really do want that, as we were talking about. If they want that, whether I'm making money off it or not, I'll try to get them back what they want. I mean, that's my job.
Well, and it's that's the sense I got though in regards to Sonny, like what do you that question, and that is looking at the whole situation. Have you ever, or how often does somebody come into your office and say, okay, here's what's going on, here's what proof I have, here's what documentation I have, and here's what I'd like.
And then there's no proof and no documentation.
But even said that,
right? No, I hear you.
And you'll ask them what they want. Do you often jump in add your experience in and say, listen, here's what you want, here's what the dangers are of going that direction, and maybe here's what's realistic? Do you ever get involved in that process based upon?
I try.
Yeah.
You're saying to try to, as I'm sure
not trying to push them in directions, but set expectations.
I'd like to think that people, as I've gotten older, I'd like to think that people.
As old as Jared here, but go ahead.
I like to think people can take responsibility for what took place, and they can accept that this is also a business. You're trying to take money from this business. They don't want to give you any money, and now you're also alleging that they broke the law, and so they don't like you too much. But and that's how I kind of approach it. I try not to approach a business with you're a criminal. This is my client. You owe them, because there's usually more. There's usually the client side of the story, you've heard, right? The company side, and then there's the truth,
Sure.
right? And not everyone knows the truth.
Yeah.
So
I mean, I've seen a situation, and where this is, it seems to me like when somebody comes to you, they're ready to move on most of the time. In other words, they're either going to quit or they can no longer take it. But
if they haven't been fired,
what's the ratio of when people come into you, and because have they been fired, or are they they're being harassed, or they're getting discriminated against, and they're going to be the one that's proactive.
That's the point. I mean, that's what you want.
That's what you want.
Absolutely. Call for I mean, figure out your rights.
I mean, how effective is the, and I never understood this. The defense by an employer stating that they didn't bring up these harassment issues until they got fired. Well, the answer in some cases would be that employer's right, and in many other cases are, I didn't want to be fired, and I dealt with it because I didn't have a choice, and I got a child at home, and I had to take this crap for a real long time.
Goes back to my earlier question. Do you need to give the employer an opportunity to correct,
to remedy it,
the situation?
You do, to avoid the affirmative defense.
Okay.
And that would be, so the answer is yes.
Can you win the other way though, Jared? Like if
there's no retaliation claim otherwise. But you're saying for the discrimination,
if
not against the employer.
If a boss was sexually harassing a woman, okay, a male superior, and he didn't, and she didn't say anything, and she just took it because maybe she didn't have, she needed the job. She knew if she said something, she was going to be fired. He was the guy. So finally, he cans her, right? Because she won't take his advances. It's just an example.
And who are we going after? Who are we pursuing? Him or the company?
Well, it's a woman who just was harassed for 3 years, didn't say anything because she was afraid to lose her job. Finally, she refused to give in to it. He canned her. Then she goes to your office and says, I was harassed for 3 years. And I refused to give in. Finally, he canned me for it. I have proof that I'm a great employee. I have all the proof in the world in regards to documentation. But I didn't go to him, and I didn't tell him. I didn't make a complaint because I didn't want to get fired. But he just fired me, so now I'm making a complaint. Can she win?
Absolutely, she can win with a discrimination claim. She was treated differently because she's assuming in this situation she was being harassed because she's based on her gender, based on her sex.
Right. And is there a difference in the?
There's no retaliation claim though, because she didn't say, "Hey, I'm being treated differently," meaning, AKA harassed because of my gender and because of my sex. So there's a distinction. So if she would have complained, she'd have that additional retaliation claim.
Okay, what's the difference in the value of both claims? That's individual.
That's a good question, actually.
Yeah, it's a great question. Well, in terms of liability, even though that's not the question you asked, that's the question I would answer. It's much harder to prove discrimination than it is retaliation, because retaliation, you just need a triggering event. Somebody complains, somebody gets terminated, and there's causation. But discrimination, it has to be a because of. Let's assume that's not the standard.
But it's sexual harassment too, though. In other words,
which is a form of gender discrimination.
Right. Okay. I know. So it makes sense. It's
the value of the claims. Retaliation's a better value claim, but again, each of them have the same pieces of damage pieces, whether it's your back pay, your front pay, emotional distress, how long it's been. Like you said, 3 years. Somebody's living with this. That's worth something. And if they seek treatment, mental health treatment, it's the value of the claim is substantial.
And you can certainly see that happening in a situation where you're an executive or a partner of a business.
Yeah.
You're experiencing some of this discrimination or harassment. you don't necessarily want to leave that job
Yeah.
because there are a lot of perks, a lot of benefits that you derive from it.
It's your identity.
Yeah.
Right.
So
It's true.
you know, what do you do? I mean, do you try and handle it yourself, or do you reach out to a person like Jared and get counsel before you do anything?
With a, how long do these claims? How long can they take it?
Oh, I mean, so you're looking at like a 3-month window, I'd say, to successfully resolve something if the client's expectations, I'd say, are realistic. And I listen to what they say too. And the more you listen, the more you find out what's realistic. But I can tell them what's practical. And I keep saying in this day and age, but it's true. The courts, you go threatening a company, first of all, they're going to say, we got rid of this person because of financial reasons. Then they're going to say the courts are closed. Good luck suing us, right? So,
Okay, so interesting. So if you do if you do file a legal complaint against somebody and you sue them, can they then, in other words, when you're going to apply for another job, can they do something to try to sabotage?
So another reason why you're going to go, well, there are defamation laws. There's also privileges to that. So if somebody calls for a reference, you can't badmouth an employee.
I see.
But if you file, so that we didn't talk about the whole process, but certain types of claims require you to go through an administrative agency, like the Equal Employment Opportunity Commission, the EEOC people have heard of. So you have to go through a 6-month process there for a lot of claims, and then you can file in court. But the EEOC process, it is public to some degree. The documents through like a FOIA request, you could get them, but it's not on Google. If you file a complaint in the Eastern District in federal court, where we do most of our work, that's on Google. I mean, that's right. That's going to be on, put in someone's name. That's going to come up.
So potential
Exactly.
new employer can search that.
Even if you negotiate this short of a lawsuit, or if you get into a lawsuit, let's say, and you sign a confidentiality agreement that says we're not going to talk about the existence of this agreement or any of its terms. Well, if that case was filed in court, it's all going to be out there in public anyway. So that's a huge consideration, especially for executives.
Yeah.
They don't
I didn't
want
know that.
Yeah, I mean, it's definitely when somebody comes in,
a lot of consideration.
If it's a sexual harassment or a discrimination in a lawsuit, do they pay you upfront money, or is it a contingency basis?
I mean, it depends, but not usually. So sometimes I'll, this day and age, I don't know if my wife's listening, but she'd probably prefer that there's a flat fee, like a hybrid,
Sure.
kind of like the schools are doing these days. But if I could get some type of money just to help me run my practice and continue, until we get to the point where there is potentially contingency. So there'll usually be more often than not, it's just a straight contingency.
Yeah.
And so you got to pick decent cases.
But there are special circumstances at times, especially if somebody just wants their job back or something like that.
Yeah, exactly. We were just talking about that. So sometimes it'll be. I generally don't charge an hourly rate for people that just got fired. It's very difficult for them to pay.
Right.
And we shouldn't judge other circumstances, right? But I understand that. So sometimes a flat fee that they can afford, if they need to break up a payment, we can do that. And then on the back end, there would be a contingency.
Now, what about, have you ever represented an employer?
It's a great question. So I have 5 or 6 long-term, small, mid-sized company clients. I'll do employment counseling.
And for HR departments and stuff like that?
Yeah, and what we'll do is we'll talk about how to kind of properly counsel an employee in a respectful way. That, because I understand what it's like on the other side. So it helps me to be able to counsel employers to avoid claims, first of all.
Sure.
To put these employees on that 3-month plan or 6-month plan.
Yeah, it's interesting though. This is, oh my God.
But I don't litigate.
By the way, so we got about 2 minutes and 20 seconds.
Oh, really?
Yeah, I mean, it's a shame. Brett, we're going to take the next hour.
Flying by.
We'll just roll with this.
Man.
But having said that, small businesses, and I'm assuming that this must happen in so many small businesses because they don't have HR departments. I mean, a lot of people start their own little company. It might be a little construction company. It's the old boys network.
Yeah.
And they need a bookkeeper. And the next thing you know.
Speaking from experience, being a small business owner, investing some money in HR is extremely important.
Yeah.
Extremely
I mean,
important.
Absolutely.
It's a-
That's what we'll do.
it's
Stuff
the-
like that sometimes. Yeah.
Best dollar I ever spent.
Yeah, and so training people who normally are not normally used to being in the corporate environment. You know, a lot of contractors. I mean,
A respectful environment, I guess you'd say, right?
exactly.
I mean,
Yeah,
Jared-
and now actually I think
Sorry.
they have these companies that will actually act as your HR person without you actually hiring
Yeah,
them.
so that's what I'll do some of that stuff for, like on the side for companies, not
Okay.
the ones I just mentioned. A little bit for the ones, but that's a regular thing. But other companies, I'll do an audit. You know what complaints are especially
Sure.
with I mentioned the other pandemic with a lot of these racial divides now. It's important that you understand what's everybody thinking. Get them in a room. Or,
Yeah.
Yeah.
You know,
Absolutely,
for all
and
these things.
sensitivity training. We got about less than a minute left, Jared. If you would, your contact information at the firm. You know,
So yeah, so you know you can find me. I'm on a bunch of different social media websites, but it's jaredjacobsonlaw.com, and I'm on Instagram. I'm doing some TikTok dances with my daughters,
awesome,
and I do some legal videos to try to help people out that I don't talk to. So
awesome. Sounds good, Sonny Banks.
Banks Law 215-561-1000. Our web address is www.bankslaw.com, and I'm going to ask Jared to come back and promise right now that he will, because we have so much more information that we haven't touched.
I would love to.
Absolutely.
I really appreciate it. Thank you guys
No,
very
it-
much.
it's
Thank
been
you,
great.
Sonny, for having me.
I want to
Good.
thank everybody for tuning into the Pain and Wellness Hour with Sonny Banks. I want to thank our guest Jared Jacobson of JJ Law for being an awesome guest. We can't wait to talk to him
Thank you.
again.
Definitely.
And I want to thank our sponsor, Pinnacle Medical Plus and Tony Schuler, and our listeners. Thanks so much for tuning in.